Okay. Good morning. This is a hearing of the Lynn Haven Code Enforcement Board. My name is Al Stopka. I'm an attorney and the special magistrate appointed by the city to hear and decide code violations or alleged violations. My powers and duties are set forth in section 2-102 of the Lynn Haven Code. These hearings are what we call quasi-judicial hearings. They're governed by Chapter 2, Division 3 of the Lynn Haven Code. The hearing procedure is specifically set forth in section 2-97 of the code. As we proceed this morning, both parties will have an opportunity to present evidence about the alleged violations. We're not bound by the formal rules of evidence here, but there may be some restrictions on evidence or testimony to ensure the fundamental due process for everyone. Ultimately, the city bears the burden to prove a violation of the code. The city must present competent, substantial evidence that a violation occurred or is continuing. The process that will follow is first the city will go present their case, and then the property owner together with any citizens will have the opportunity to address the issues and present any evidence or testimony for my consideration. You have the opportunity to provide both oral testimony as well as pictures or any documentary evidence that you may want me to consider. As each individual is about to testify, I'm going to ask you to say your name, address, and I'm going to swear you in for your testimony. Okay, so with that, we'll go ahead and start with the first hearing. Do we want to go with Mr. Wade's property? Or Mr. Finch's property? Okay.
This is Vicky here, has another meeting here right behind this.
Okay. All right, so the first case we're going to call today is going to be City of Lynn Haven versus JDF Properties, LLC. That's case CE-20-781 regarding the property at 201 West 14th Street. All right, Officer Odom, if you raise your right hand, please. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please state your name for the record.
Kerry Odom.
Okay, please proceed.
I'd like it read into the record that the full package be accepted as evidence, and based on the evidence presented, staff recommends that the special magistrate find that there has been a violation by the respondent to the city's municipal code in the form of maintaining a nuisance, no development order, unpermitted work on the property located at 201 West 14th Street in Lynn Haven. And request that the fine be assessed against the respondent to include a penalty in the dollar amount of $250 per day, identified below, starting on the 10th day until the nuisance is abated, and a $200 assessment for the cost of the proceeding, all to be paid to the city within 30 days unless a notice of appeal is duly filed. And so paid, the city is authorized to place a lien on any real or personal property with a foreclosure thereof is allowed by law. Staff also requests that the special magistrate authorize the city to immediately install silt fencing around the property to contain the sand runoff coming from the property that the rain is washing into storm drains and in storm ditches. Staff also requests that the property owner obtain the necessary permits required to bring in field dirt and raise elevation of the property. Staff also requests that the owner obtain a development order and a stormwater runoff plan and a holding pond to help prevent potential excess flooding of the surrounding neighborhood and the streets in the area, with the cost thereof imposed against the respondent, and if not so paid, that a lien be placed on any real or personal property thereof is allowed by law with an annual interest rate of 10%. Staff also requested the city of Lynn Haven and the vendors be granted permission to access the property to estimate the abatement costs.
Okay, without objection, I'm going to go ahead and accept the package into evidence. And I've already had a chance to look at that. So, Officer Odom, tell me what's going on.
This property was once a trailer park. Mr. Finch has apparently purchased the property since then. And he brought in probably approximately about 16 inches of field dirt in on the property. It was just brought in truckloads and was in random piles throughout the property for a while. We reached out to Mr. Finch in regards to the dirt being on the property, and he had stated originally that it was for a project he had with the power company. After several months went by, the city started addressing the issue because of no silt fencing and not protecting the dirt from getting in the right of ways and then into the drains and the easements. And Mr. Finch went in and actually had someone grade all the dirt out on the property, more or less to bring the property up elevation, which appears to be prepped for site work, for potential building. With that being said, there are permits needed to do so. Mr. Finch said that after I talked with him about grading the dirt out, he said that he was going to get with the planning department. He called in Mr. Ted Shoppy, which is your superintendent, correct?
Right.
And advised Mr. Shoppy to contact Amanda Richards in reference to getting her what she needed for development order. From that point, Mr. Shoppy did not reach out to her, according to Mrs. Richards. And then I wound up moving forward with writing the property up for violation. At that time, I met with Mr. Finch in his office, and he advised me that this was dirt that was going to be used for the DOT project. I kind of, it may be dirt used for the DOT project, but it kind of seemed like it'd be more useful if it was in one big pile than spread out across 2 or 3 acres of property at a grade level. We issued a stop work order on the property on the 5th, January 5th, and Mr. Finch sent a letter on the 19th that stated that Finch Construction was using the property for storage for materials and construction to expand the State Road 390 and 6 lane. So there would be no construction on the property. Some base material would be brought in to keep construction materials out of groundwater. Various properties are being used along 7-mile stretch of construction currently underway. The property will be kept in a professional manner. I traveled the entire stretch of this property, and about 99% of everything that is related to that project is on the right of ways, on the streets and the existing construction. There is a few sites on the side of the road that are what we'll call lay-down yards that are storing pipe and things like that, but none of the elevation has been brought up like the elevation on this property. All the elevation meets what's next door to the adjacent properties. Mr. Finch has been asked to just obtain a development order for bringing in the dirt on the property. He is required. It's his personal property. So even if he's using his personal property for storing dirt for the DOT, it's a personal property that he's actually raising the elevation on. He is required to have a development order to bring in an X amount of dirt on the property.
Let me ask you this. As far as the other yards that are being utilized for the FDOT project on Highway 390 and the subcontractors' uses of those properties, are those other properties, are they part of the overall permit for the Highway 390 project, or did they have to come to the city to get any sort of permit to have a storage yard or anything like that for the other areas?
Well, the other properties are outside of the city.
Okay.
They're in, I think some of them are actually in Panama City, maybe even county. That area down through there is kind of chopped up. So, like I said, the rest of them, anything else that's in Lynn Haven is pretty much right on. It's stored on the right of way where the highway is going to be built.
And I'm assuming the FDOT doesn't have any overriding permit allowing for storage off the right of way within the city of Lynn Haven for dirt or refuse or anything of that nature in relation to the Highway 390 project.
Mr. Finch says that he has the right to do so, but I have not found anything and he has not produced anything that says different.
Okay.
These are pictures taken the last 2 or 3 days with the rain. Some were taken this morning. And you can clearly see that the washout and then the sand going into the storm drains. The streets are flooding in that area. These pictures are from this morning, 2 days after the rain.
Right. So even if it was being used as a storage yard, there's still no silt fencing containing the dirt.
Correct.
Okay. And do you know, would a commercial property like this be usable for a storage yard? I looked at the code and it wasn't a permitted use, but I wasn't sure.
Right. If being, if he was bringing it, most anywhere else bring dirt in, they push it up in one big pile, and they go in and they get the dirt as they need it, they pull it out. To bring in 200 loads of dirt and then grade it out to a grade across the whole entire property, it seems more of a hassle to try to reuse that dirt. I mean, it can be done, but it seems like more of a hassle to reuse that dirt to put on the highway, because now you gotta go get it from here and over there and over there and over there and over there versus just one stockpile.
Okay.
I don't consider that a stockpile of dirt.
All right. Anything further from the city?
Mrs. Biggie?
I'm here from the planning department.
Okay. Would you raise your right hand, please? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And can you please state your name?
Vicki Harrison. I'm
Okay.
the planning specialist for the city of Lynn.
Okay, please proceed.
I was prepared that the city has not received a development order application from Mr. Finch for this parcel. It was brought to the city's attention that loads of dirt was being brought in and placed on the parcel in the pile. And then it was brought to the city's attention that the dirt had been spread out on the parcel. Per the requirements of the ULDC Chapter 10 Administrative Procedure, Section 10.00.02 development permits and local development orders required. Item B, number 4 states, any other construction, reconstruction, site improvements, or modifications to the land or water on the site. So that means they have to have a development order to do that. And then item D, no development permit shall be approved unless all required local development orders necessary to the development activity proposed in the development permit application have already been approved. So these codes are in place for when a development order is submitted. Stormwater calculations are submitted, and then they are reviewed by an outside engineer for ponds or weirs or that type of thing. As well as floodplain management is reviewed, and because we have to ensure that our community rating system, the CRS system category, is not affected. Ms. Richards spoke to Mr. Finch regarding the dirt that was brought onto the property, and he indicated it was a staging the dirt for the FDOT. The property did not belong to the FDOT, it belongs to Mr. Finch. Ms. Richard asked for evidence of the FDOT permission, and Mr. Finch never provided the evidence to her. Then Mr. Finch also had spoken with her and stated he had spoken with the head of the Water Management District as well as the Department of Environmental Protection, DEP. And Mr. Finch stated both agencies had told him the dirt was not a problem. And again, Ms. Richard asked Mr. Finch to provide evidence of those permissions, and Mr. Finch never provided any evidence or permissions to her. As of today, we've not received anything.
Okay.
Or development.
And so there's no development order, and likewise, there's no development permit nor development permit application. Is that correct? Okay. All right. Anything further from the city?
No, I don't believe so. Other than, I issued a stop work order and asked for this to be resolved through permitting issues, and despite the development or stop work order, Ms. Finch, at a later date, this was on the 5th, on the
19th?
18th.
Or the 18th?
Right around the 18th, he started bringing in dolomite rock, and he built that up another 16, 18 inches on the south end of that property. And I don't know, if that's all he's going to bring in, or if he's going to bring in, 50 more truckloads or what have you. But at this point, this area has severe damage severe issues with flooding. These apartments were completely flooded out when Sally came through, and this is not gonna, it's right next door to it, so it's not gonna help it at all. In the event we get another 4, 5, 6 day rain, it's gonna be tragic for these people in this neighborhood.
Okay. Anything further?
No, sir.
Okay. Mr. Finch, did you want to address this?
Yes, I do.
If I get you to raise your right hand, please. Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And could you please state your name?
James Finch,
And what's your business address, Mr. Finch?
1805 Tennessee Avenue,
Okay.
Highway 39.
And are you the principal of JDF Properties LLC?
I am.
Okay, what would you like me to consider?
Well, as you know, that was a trailer park. And so when they demoed the trailer park, they took up all the slabs, they pulled out some of the water and sewer, because there was 84 trailers there or whatever. There were holes all in it. It was, it was unsafe to walk around, whatever. I brought the field in there, level the field. There's 2 drains there. The stormwater drainage is improper in Lynn Haven. 90% of Lynn Haven's got stormwater problems, and the stormwater has been a problem. I graded that off. I was to use it to store for the Highway 390 project, which you go down through Highway 390. I've got 3 or 4 properties rented from people to store material for the 390 deal, which I'm gonna do the base. And when we start taking out the intersection there at Highway 77 and going through the intersection of 77 and Ohio, going to have to do that at night, and going to take out 12 or 14 inches of millings to take over there. So I got the property, I tried to lease the property. They were selling the property, so I wound up buying the property. I brought the elevations up where it would be safe. I mean, the stormwater's always been a problem there. I mean, just because it's rained here 3 or 4 inches, it's puddled up there. But they took out 84 slabs and took out some water and sewer, so it would have been like a motocross track if I hadn't put the dirt in there. So I'm planning on using that for storage to put the pipe, the millings, the base rock, and everything to do all the intersection. The Highway 390 job goes through 77, about 600 or 800 foot on the east side of the street. So I have that rented. I got the property down there close to Moore Junior High, where I piled up the 100-foot high dirt there. It's a 3-year project, April 2024, when 390 will be through. I've got Jinx Avenues in Lynn Haven. I've got 3 or 4 places. Lynn Haven breaks up and goes. I think Lynn Haven goes as far as the Plaza Prison down there, doesn't it? The DOT camp.
It's about where Jinx and 390, but like I said, right in there, it's cut up. We got 1 or 2 or 3.
I'm doing it, but it's on the construction. I'm doing the construction of 390, and we've always used it. If you see across the street, we've got pipe stored on the right-of-way all down through there as far as doing the thing. But as far as the safety on the deal, there's going to be several hundred loads of millage that's got to be staged there. Or I can't stage it, and it is commercial property, but I can't stage it in those people's houses around through there. And I've got a $90-something million contract from doing 390, and it's staged everywhere. We stage it on Michigan Avenue, we're staging it at the main places through there, and we fixed it as far as the runoff. And like I said, it was going to be a motocross track. When they took all those trailers out, they come in there and took the trailers out, and they snatched the slabs out. They didn't bring any dirt in there. They didn't level up anything. I leveled it up. It looks a hell of a lot better than it did. And it's got to be used. I mean, I got the water management over there. They said, there's no problem. It says, you got to have somewhere. I get a stop water act here. I go to the development department. They said, well, I got to have a complete development order. Well, I'm not developing the property. I don't know what I'm going to build there, so I can't do any stormwater calculations. I don't know if I'm going to sell the property as is or, whatever when I'm through. But as far as that, and then exemptions in your land code, you've got to have, Lynn Haven's land code is different. It hadn't been updated in 50 years probably. But it's not, you can't go get a partial deal to do your side water. You got to have a complete set of drawings, what they're telling me. Well, I don't know what I'm going to build there. But as far as getting a partial, they don't want to give you a partial clearing permit, they don't want to give you a partial field permit, they don't even want to give you a stormwater deal. I've got with me here that the Glen Haven code has changed over here where I live. They're bringing up the flood elevation to 11 or 12 feet down on 2nd Street. Well, I start bringing some dirt in there, I get a stop work order there, I can't bring dirt in there. So I finally go up there, and they said I couldn't get one, but they issued me a permit to bring in some field over there on that last stop water, order you did. I get them 2 or 3 times a day, I get this over here, the grass ain't cut. Glen Haven's got more problems than I got. I've paid the fines, I don't mind paying a fine if something's wrong, but there's gotta be some progress around here. And I've done over $750 million worth of work since I've been in business. And on these DOT right-of-ways, I've never had anything like this happen on doing it, because it's progress. You know what I'm saying? I remember when they had pipe stored in down on 23rd Street, never stored down through there. I mean, it's pretty much progress. As far as the stormwater around there, the stormwater, I would like to do I would like to fill my place over there and get it up to the 11 foot that the flood zone says. But they won't give you a partial in their code here from Amanda here. You see the exemptions. If you'll read the exemptions and what you can and can't do on your land code, you can't hardly do nothing. I mean, why can't you go get a partial deal? Y'all, I've seen the city give out partial permits for clearing and grubbing, and the code says you can't do that.
Right, I think the main concern is the size of the property versus raising the elevation about 12 inches.
Well, I mean,
It's just pushing that water off.
If you didn't raise it up, those kids are gonna get hurt in there in all them holes.
Well,
I graded it out. But like I say, when you take all that stuff out of that intersection and you pile it in there, what the hell's gonna happen then? Because you gotta do that at night from like 11 to 3 or 4 in the morning.
Right.
You gotta get it out of there. And so I didn't wanna buy that damn property. I got the property so I can do the job.
right.
Mr. Finch, let me ask you this. The clearing of the property and the removal of the mobile homes, was that done prior to when you purchased it?
During the same time, they cleared it and I made them clear it to purchase it.
So the previous landowner cleared it, so you weren't involved in that?
He
Okay.
did the demo.
And then JDF Properties, does that have a contract with FDOT for the 390 project?
No.
Okay.
Finch Construction does.
Okay.
On both JDF properties there.
Is there a lease or a contractual agreement between JDF Properties LLC and Phoenix Construction for storage on that property?
Yes, there's a mutual agreement.
Is there a written agreement
I can
between?
have one, but I mean, I don't know.
I'm just asking the question. I was sitting here today wanting to kind of know what's going on.
Give me a pencil, I'll give you one back.
I suspected that, so that would be the case. Okay, anything further, Mr. Finch?
Well, like I say, there's no, the land code there doesn't give me the right to do that. And like I say, he goes down there and stops me from bringing in dirt on my land down there because I want to get up the elevations for stormwater. I got to see what I got to do with stormwater. They raising the property down there 5 or 6 feet down on 2nd Street. Well, 5 or 6 feet, I'm gonna put it in there and then let the city look at it because it's gonna throw. They're gonna have to do something. It's gonna throw that water in everybody's house.
Well,
Everybody's
the
house.
code for residential property in any development is post-development, pre-development, has to be the same as stormwater control.
And I understand, and I know your residential property on 2nd Street is not the same as
Right,
the
okay.
commercial property on Tennessee
Read
Avenue.
the
so-
exemptions there and see what I can do.
Yeah.
What could I do?
And I understand that. So, do you have any other evidence or testimony for me to consider?
Well, I would like to know the exemptions that I can use that property for the storage there. I don't see where, if when I go lease property up and down 390 there, people's commercial property or their residential property to store, there's not a problem with the DOT. That's what DOT tells you to do.
Yeah, in looking at the exemptions under section 1.03.02, I don't think that there was any exemptions that were applicable to this situation unless you can point to one. I didn't see it in my review of the information as far as the need for a development permit in this particular situation.
Well,
So,
do you read that you have to have a whole development before you can get anything from the city? That's the way I read it.
Well, I'm going to rule on that in a minute, but I just didn't know if you had anything for me to consider in relation to that, other than the fact
When
that
I
a
talked to
partial.
Amanda, she told me I had to have a full set of drawings of what I was going to do before they could do any stormwater calculations. I said, I understand that, I'm not ready for that, I need a partial. There's 2 or 3 trees there that I need to take down. I've not asked for that permit because they give me a stop work permit. I think there's 3 trees, would you say there's 3 trees on the place? 3 or 4. I wanted to take those down, so I just quit till I come to this hearing. I didn't know about this hearing till I seen a sign. I got the letter this morning, but I seen a sign on the property yesterday, and we stopped and looked at it.
I understand, and from review of the evidence, it looks like that a notice was provided and there was certified mail receipt that was sent back. It was signed for by somebody at 1805 Tennessee Avenue. In looking at the evidence, I can't read the signature, and there's no date on it, but that's not surprising either. I'm sure there's tracking data associated with that number.
I found it yesterday, but I'm here.
I understand. Okay, anything further?
No, sir.
Anything further from the city?
I don't believe so.
Okay, in looking at this situation, I think given the provisions of section 10.00.02 of, let's see, is this the UDL? Or is this of the UDL for Lynn Haven, that a development permit, and I'm using the word permit because that's specific within the language here, is required for any on-site improvements. And given the fact that there's grading going on the property, that there's infill and landfill on the property, that I think that constitutes an improvement to the property. Obviously, it's changing the elevation of the land. And in your testimony, you indicated that you needed to improve the property basically to make it usable for your ultimate intent, which was additional storage of materials on site. So I think given the requirements of the UDL here in this section, that a development permit would be required, and the fact that a development permit has not been obtained means that there's a violation. I think the stop work order is appropriate. I also think the city's request for a silt fence is appropriate, especially given the fact that it looks like the grading is up to the right-of-way, or at least up to the drainage areas.
Given one drainage box there, we stay away from it.
Yeah, and I saw the drainage box. I also saw the runoff in the pictures showing runoff from the property into those pictures. So I think that there is a violation here. I'm going to grant the city's requested relief. You need to, is it application or obtain a development permit within the 10 days? What are y'all looking for?
I'm sure if we get the process started,
Yeah, he could submit a development order application and just, with his stormwater calcs or what he's wanting to do to disturb the property. As far as I'm aware, I'm just sitting here on behalf of Amanda for today. She had another appointment. But that's my understanding is just, there can't be any site improvements or modifications until a development order is pulled. And I understand what he's saying about he might not know what his future plans are, but even with that, any changes to that parcel involving dirt being brought in or spread out and all that, he'd still have to have a development order for that.
So application within 10 days, is that what the city's looking for?
Yeah.
Because I don't think he's going to get a permit within 10 days.
well,
Right.
I mean, if they can give him, if they're gonna work with giving him a partial.
We're gonna go in here. Develop order for what? I'm not developing a property. I'm gonna use it for a storage for the,
It's because it's the land disturbance, it's because of the land disturbance on the
well,
property.
what about all up down 77? Have I gotta go get all those done too, where I've got all the rest of the storage for the DOT subject in Lynn Haven?
And Ms. Finch, I'm dealing with this particular piece of property this morning, and so that's the issue I'm dealing with. And given the code requirements, there's an obligation if there's any improvement of the property, and infill and landfill like this would constitute an improvement to the property.
Is storing material an improvement?
If you would have brought that property and just put the minimal fill in it to get it at street grade,
Well, what was required on y'all's demolition permit for them to do? You issued a demolition
I
permit.
didn't issue demolition
The
permit.
city did.
The building department issues those.
Yeah,
well,
the
that's
building
what I'm saying.
department issues
What was the
permit.
requirement there? There should have been an elevation there, what it was.
Well, there-
I brought it in to get it out of the groundwater and to make the property safe. up to a level, it looks a hell of a lot better than it did when it was a trailer
I don't
park.
doubt that a bit. I
And
agree
then,
that it
like I
looks
say,
better,
I've
but
got
it's
to
not
bring in
working.
several loads of base, all the base material that comes in there.
And Mr. Finch, I completely understand what you're saying and where you're coming from, but the issue that I've got is that the property was improved or modified in order to make it usable for your ultimate intended purpose,
Okay,
which is
well,
bringing in base fill.
Okay,
So, and I think
fine
that
for that, but what am I saying about going forward?
and going forward, my reading of the code is that you're required to make an application for a development permit. And whatever that process is and whatever is required has to be done. And
You read it as a full development order, that I gotta have a set of drawings and stormwater calculations?
I'm reading subsection B here that says a development permit. So whatever is required for a development permit is what you would have to do.
Well-
And you can discuss that with the city as far as ultimately what the application process is, but a development permit would be required in this particular situation.
On this deal, the other one, I got a partial deal to bring in the dirt on down here.
Right.
I got a partial, if I can get a partial there, I'll put in for a development order or whatever.
And that may be a situation that you can work out with the city. My ruling this morning is that a development permit was required, one was not obtained, there's a violation of the code as a result. Application for that needs to be made within 10 days of the date of the order. If it's not made within 10 days of the order, I'm going to assess a fine of $250 per day until one is obtained. And I think the stop work order is in place and stays in place until that permit is issued. Likewise, I'm going to assess costs for today's proceedings in the amount of $200. And fines will accrue, like I said, in the amount of $250 per day until the situation is...
After 10 days.
After 10 days, yes, sir. Until the situation is resolved and you've gotten that development permit application filed. Any fines which accrue, together with the cost of today's proceeding, will accrue interest at the statutory rate and act as a lien against the property until they're paid in full. Ultimately, what will happen is I'll go ahead and prepare a written order with today's findings. You should get that in the next few days. From that, the date of that order, you have a 30-day time period in which to appeal this matter to the circuit court should you so desire. So you have an appeal right to do that.
Okay, I can go to circuit court.
Yes, sir.
Like I say, I've got to get a partial development order. And I'm not going to put an eight-story high-rise there and do all the calculations before I can take those trees down.
I understand that. And the way I'm looking at it from right now is the raising of the grade on the property and the filling in of the job site was an improvement to the property which would have required a permit. And I'm not looking at ultimately the ultimate use of the property, but right now you've modified the grade of the property in order to make it usable for on-site storage for your construction project. So that's considered an
Let me tell you
improvement.
something, I'd rather pay the $200 because you won't change the code, because I couldn't do it, because you says I can't give you one. I can't give you a partial development order. You'll need to change those codes as 50-something years old.
And obviously that's something to address with the commission because they have the authority to do that. I don't. So I just apply it the way it is.
I want to show you the difference. County, 10 acres over there to clear, $10. Half acre, $100, see you later.
And like I said, that's a political decision for the commission. That's not a decision I can make. All I can do is apply the code the way it's written.
I need to address somebody, I guess I need to address the commission on it, because if you're going to get this stormwater deal up over here, they've got to change the code so I can go in there and fix the property. Because when somebody fixes the first piece of property over there, it's going to throw the water in everybody else's house.
And Mr. Finch, I don't disagree with you that the city has significant stormwater issues. The change in elevation in the city probably is 10 foot from one side to the next. So, but that's obviously something for the commission to address, not for me.
Yes, sir.
Okay, so I'll send you, or the city, excuse me, will send you a copy of the written order with my findings today, and you'll have 30 days from the date of that order
Okay,
to appeal the circuit court.
last time y'all fined me $200, I paid the $200 to the city and they forgot to record it. And then, they liened a piece of property, they liened all my property, not this piece of property over here, they liened it over there, so I finally got the city to release the lien. It was a $2 million piece of property over on 390, and that $200 held that up, you know.
I've seen that happen
You
before.
remember that?
I do.
Yeah.
When you do pay it, make it out to code enforcement at City of Lynn. That way it comes to us and we put it directly in the system and clear.
Yeah, I just paid it to the city of Lynn Haven.
But if it goes there, I don't know it's coming in.
We never did find it.
Right.
We found the check.
I understand. Folks are human.
Okay, well, you don't see any problem as far as, I guess I'll take it to them, and, who do I go to now? To the building department, I go to city commission,
Planning department.
Planning
Planning
department,
department.
you go sit down with Amanda and, you need to go sit down with Amanda.
Yeah, okay.
And
like I say, it's gonna be, that intersection there is gonna be a major job there.
And I know, I was in Stratton, been there 10 years, I know exactly what's gonna happen at that intersection, but just get her what she wants. She can get you a parcel, like you told about, and then after it's over with, you grade it out, clear it down, and tear it back out.
Yeah.
That may work, but I can't make that decision. It'll have to be the planning department.
Yeah. Okay,
All right,
thank y'all.
you're welcome.
Thank you.
We're going to move on to the next case.
Thank you for coming. Thank you, man.
Next case is case CE-20-136, property owner Robert R. Wade regarding 305 Montana Avenue. Officer Odom, are you presenting this one?
Yes.
Okay, can you please raise your right hand? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And can you please state your name for the record?
Carry over.
Okay, please proceed.
I'd like it read into the record that the full package be accepted as evidence based on the evidence presented. Staff recommends the special magistrate find that there has been a violation of the respondent in the city's municipal code in the form of maintaining a nuisance, unsheltered storage, trash, rubbish, and debris, junk vehicles, no development of order or unpermitted work or on the property located at 305 Montana Avenue, Lynn Haven, and requested a fine be assessed against the respondent to include a penalty in the dollar amount of $250 per day, as identified below, starting on the 15th day for the next 15 days or until the nuisance is abated, and a $200 assessment for the cost of this proceeding. All to be paid to the city within 30 days unless a notice of appeal is duly filed. If not so paid, the city be authorized to place a lien on any real or personal property where foreclosure thereof is allowed by law. Staff also requested special magistrate authorize the city to abate the nuisance by having the trash, rubbish, junk, debris, abandoned, discarded objects cleared from the property, as well as junk vehicles or derelict vessels or campers removed from the property that is not registered, tagged, or permitted, with the cost thereof imposed against the respondent, and if not so paid, that a lien be placed on any real or personal property thereof is allowed by law with an annual interest rate of 10%. Staff also requests that the city of Lynn Haven and the vendors be granted permission to access the property to properly estimate the abatement cost. Staff also requests that this violation reoccur, it be considered a second offense. Pictures from this morning. This property had a home on it to begin with. It was severely damaged by Hurricane Michael. Mr. Wade had applied for a PPDR program where FEMA would actually come in and clean up the property, and so we were ordered pretty well by FEMA to kind of just leave it alone. And once FEMA came in, the only cleanup they really focused on was the actual structure of the home, and that was it. Most all other trash and debris was left, miscellaneous items. And this property has been a hot and heavy complaint to many people in the neighborhood over the past 2 years. And I've tried to explain to them that it was a PPDR program and it really was out of our control at that time. FEMA coming in right around Christmas and demolished the home, and once they did that, they were gone, and that is it for them. At this point, I have several boats on the property. There's some kind of unsheltered storage behind a makeshift fence he has in the back corner of the property. He has a utility shed that he drug in there as a frame. They framed it up, built it. It was unpermitted as well. The boats and stuff are not registered. They have different motors laying around in the yard for the boats. The storage around the camper is just quite a bit. The city back in November started reevaluating the camper issues to move forward with people that were staying in campers. The utility department got together and with code enforcement, and we went out and did a survey on all the properties that still had campers in the property, which appeared to be living in or staying in or that was connected to city sewer and water. Mr. Wade's property was one of those that has a camper in the front yard, so the utility department mailed a letter out to all the parties throughout the city that had a camper. They were required to reach out to the city commission, and each one's going to be seen on a case-by-case basis. Battling insurance, you're in litigation, what have you, it may grant you extended time. With this letter being sent out, there's been no response from Mr. Wade from the city in reference to it. So at this point, the camper is not permitted, and he honestly, with the dates that the city moved forward and set forth, end of this month is his deadline anyways on the camper, being he has not reached out to the city. So with that being said, the city would like to see the property, the remainder of the property cleaned up, the derelict boats removed, and the camper removed from the property, and the rest of it cleaned up.
Okay, let me ask this. So I get the unsheltered storage, the junked vehicle, is that relating to the boats?
There was a pickup truck there too, that was back there behind the fence. I think the pickup truck has been removed. I think he's added on to the fence here lately, so you can't really see 100% what's behind there. You can still see some stuff, but I think there's three different boats sitting on the property that doesn't appear to have any current registrations.
The boats don't have current registration on their bows, correct?
Right.
Okay. And then what is the issue regarding the no development order unpermitted work? What is that associated with?
That would fall under our, since the storm, we really didn't have a permit for campers. So the city did require a little application fee and a permit for everyone that was staying in a camper. And for a while, and we still have some folks that come in, the city, every 6 months they reevaluate it. The city gives them a little permit, they stick on the window of the camper, and that these people have been in to do their paperwork. He has not come down at all and applied for any of that.
Okay. So in looking at the letter, though, there was a February 28th deadline that was given, and we obviously haven't reached February 28th yet.
Right.
So, okay. So that's the unpermitted work, no development order solely relating to the camper.
The permitting of the camper, correct. And the shed that he built. He did build a utility shed there on the property. In some of the pictures, you can see actually just a frame of it. And
I saw that.
This morning, you can see it's actually closed in and walled in now.
Okay, so there was no permit obtained for the shed,
Right.
correct? Okay. Okay, anything further from the city?
No, sir, I don't think so.
I'm going to accept without any objection, I'm going to accept the package into evidence with the pictures. And did you take those pictures that are in the package?
Yes, sir.
All right, and the pictures that were taken, were they taken on the dates noted on the pictures?
Yes, sir.
Okay. All right. And Mr. Wade, correct? Okay. Did you want to speak on this?
Sure.
All right. Would you raise your right hand, please? Do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please state your name.
Robert Wade,
And Mr. Wade, what's your current residential address?
305 Mountain Avenue.
All right. Go ahead and tell me what you'd like me to consider.
I was going to build a shed, but I didn't, and I have a shed that I did get a permit for from the city of Lynn Haven.
Is that the shed that's that has a
Yes.
siding on it? Do you have a copy of that permit with you
I
today?
do not.
Okay.
I had it stuck on the front door, but I guess it was wet on, nothing there now but tape.
Okay. Do you have a receipt from where you paid for the permit or made a permit application,
No, I
anything
remember
like
it was
that?
like $175.
Okay. All right. Okay,
Uh,
keep going.
I have 3 boats, 2 are registered, 1 of the 2 is current. Actually, I'll take that back, both of them are current.
All right. And do you, by any chance, have a copy of the current registration on those boats and the tags for them?
I do not,
Okay.
but the stickers are on.
And do you have any pictures showing the stickers on the boats?
I have nothing, I didn't read anything.
Okay.
Because I just looked out the yard one day and I saw a sign. I received a letter Friday, so I didn't see it till Friday night. Yesterday was the first day since they've been open. Officer Carey and I have phone tagged each other as far as, you know, I've called him, he's called me, we haven't called up. I just got a letter stating that I had code violations. It didn't say what the code violations were. Now, I have to clean the property up. If you see, if you went this morning, I imagine you saw the big difference. from what you
Yeah,
see
I
on the
mean,
road.
I do agree since, I guess right about the time the FEMA comes through, you have made some improvements.
Yeah, I mean,
give you
that's like a mess. And,
But,
they actually tore my driveway up. They were supposed to come back and dig it up and haul it off. Half of it.
but with the community, the neighboring properties that, I mean, I can show you some emails that the city of Lynn Haven just absolutely getting hammered.
Oh, well, I have one
About the
neighbor, he has a
conditions of
sign,
your
you know, he has a sign that's big. You know, probably 3 by 2, that has landfill pointing at my place. Now, I have applied with this, when I started with Rehouse Bay to see if I could have my house built, and now I'm switching over to Reeville, Florida. They say they're gonna, you know, any pre-work, they'll come into the stuff, cause they tore the house down, they did the foundation, or parts of it, you know, broke up stuff. We'll clean that up. I had one tree I ended up having to do myself, and I've got a big stumping yard I'm working on.
Yes, sir.
And I'll have a garage, you know, to put myself in. But, I had, you know, a shed, I had a carport, and all that was taken with a hurricane.
What is your intentions with the boats that are on the property that?
I'm getting rid of one, and one I'm giving to my grandson for his birthday, and one I won't keep.
And they're leaving the property?
2 of the 3 will leave, yes.
Okay. You will have to get with the city in reference to the camper.
Yeah, well, I get my house built, the camper's gone.
Right. That's,
Now, and also, I applied when they first started it, I first brought it there, I applied and got the permit, And then, when it expired, I got another one. So I paid twice for this, to have it, you know, with the camper.
Well, I know they tell me that they haven't got anything on record from you for a camper.
Well, I can't help that, I've done it, it started with Mr. Brown still, you know, coming enforcement.
Okay.
And when I went down to get it renewed, he was working, he had changed jobs, and didn't work for a different department.
Okay. Let me ask you this, Mr. Wade.
And I'll go down and get another one, you know?
Mr. Wade,
That's the problem.
in looking at the property appraiser's website, it looks like you do not have homestead exemption on this property.
Well, I went down there too. The first time I didn't have it, and then I thought I have it now. I still don't have home exemption.
Yeah, but it's showing on the computer that it's not, and that's why I asked, because you indicated you were living, I guess you're living in the camper on the property, is that what you're doing?
I mean, it's the only property I have.
Okay, and that's why I just asked that.
The first time I went down there, because I bought the place just prior to the hurricane, so I went down to there and they said I had to wait till the first of the year to go down there, you know, claim it.
Okay,
So I thought that's what I did.
all right. Anything further, Mr. Wade?
Yes, I didn't realize that I had forgotten about it till this came up. And I went down to pay the fine last time. You know, I was fined.
Right.
And they, you know, they didn't know that's all I told me to call. Actually, they said this in a text to code enforcement. You know, asked them to call me, but I didn't catch the call. I'd like to go ahead and pay that and clear it up.
Okay. Well, and you can call the code enforcement office about that, or whoever, the city clerk, or I don't know where they have to go to pay that.
He can call the police department and they'll forward it back to us.
Okay, so just call the police department as far as that's concerned. Anything
Okay.
anything further, Mr. Wade?
I certainly don't think I should be fined for the cost of this. At least this is the first I've heard of what my violations were.
Okay.
And you can give me time to whatever you know I need to get, I'll take care of it.
All right. Anything else?
Nothing.
Anything further from the city that the city would like to
No,
have me
sir.
consider? Okay, and I just need this clarification. In looking at the notices that were provided for today, I'm sorry, the previous notices that were given, I'm looking at a notice of March 3rd, 2020 and March 18, 2020, it looks like.
That's correct.
And in those, there's the general violation of maintaining a nuisance. Then there's unsafe, unfit dwelling in both of them. I'm assuming that applied to the actual house that was on the property that's now gone,
That
right?
is correct.
Okay, and then I see unsheltered storage and accumulation of rubbish, trash, and junk in those, okay. And then in looking at the notice for today's hearing, I didn't see any specific violations addressed within that notice.
That's correct. Usually the hearing notice doesn't
Right.
include it at that time.
Okay. Is it the city's position that the issue of the non-permit associated with the shed or the junked vehicles would fit under either the unsheltered storage or the accumulation of rubbish, trash, and junk provisions?
I would say it would fall pretty well in that category.
Well, I haven't seen pictures from today.
If you can, Mr. Wade, I'm just asking
They're
questions.
definitely not in operating condition. I mean, you can kind of clearly see that in some of them that the parts are missing on them. Some of them have junk piled up inside of them. So.
Okay, all right. And Mr. Wade, what did you want to say?
I haven't seen pictures from today, but I'll imagine.
Well, you can look at them.
I'm saying you should see a junk or rubbish.
Okay.
You know, around the camper or anywhere else. Everything, you know, that I have worked on it and continue to work on what's behind the fence.
Okay. Anything further from either party?
No, sir.
Okay. I want to note for the record that this property has been the subject of 2 prior cases that have come before me. The first case was 17-03-152. That was a 2017 case that resulted in an order associated with unsheltered storage and weeds and underbrush on the property. And then the second case was case 18-08-136, which was a 2018 case that also resulted in an order regarding unsheltered storage, no sewer hookup to the home that was on the property at that time, in addition to weeds and undergrowth on the property. So this is the third time that this has come before me regarding unsheltered storage, and in looking at the pictures that have been presented, I believe that there's still unsheltered storage on the property. This has been a consistent problem with this property. This is not only a second, but a third violation, basically, of the same thing. And I think the city's probably given you some leeway with the hurricane, but we're now more than 2 years out, and there still is trash and rubbish around the property. So I think that is definitely a second violation. In fact, it's a third violation on that issue. I also find that the boats on the property could be considered junk or abandoned, given the fact that they are. The pictures that I'm looking at don't show current registrations on the vessels. They don't have tags on them. I know you've testified to the fact that they are currently tagged and licensed or have registrations on them, but I have no evidence of that other than your testimony, and the pictures indicate otherwise. So I find for the city on that issue as well. As far as the issue of the unpermitted structure, I'm concerned about the due process issue on that because I don't think that was noticed for today. And I think had it been noticed, the lack of permit associated with the shed probably would be actionable and be a violation. But I don't see a notice for that, so I'm concerned about that. Likewise, the issue of the trailer, while that ultimately may become an issue, one, I don't think it's noticed for today, and then secondly, the city specifically provided a letter giving them until February 28th to remove the trailer or obtain an extension permit for the trailer. So I think that that's not a violation either. I'm going to go ahead and grant the city's relief as to the unsheltered storage, the trash and rubbish, including the boats on the property. Those conditions will need to be abated within 15 days of the date of the order. Failing abatement of those violations, fines will accrue at the amount of $250 per day until abated. I'm also going to go ahead and issue a fine or award costs in the amount of $200 for today's proceedings. Also, in the event that the condition is not abated within 30 days, the city will have the right to go on the property and abate the violation. Any cost associated with abatement of the violation will also act as a lien against the property, together with any accrued fees and costs until they're paid, and they'll accrue interest at the statutory rate until paid. What will happen is, like Mr. Wade, like I've done with you before, you're going to get a written order from the city with those findings on it. You'll have 30 days from the date of that order to appeal to circuit court should you so desire. And obviously the city's not prejudiced to bring up those other issues as far as the unpermitted structure of the trailer and any other conditions that may exist in the future.
Prove I have registration on the two of the boats, can they stay?
Today was the day to do that. I'm sorry, I don't have that evidence in front of me, and the evidence I have,
Well,
I give weight to the evidence that the city presented, which was photographic evidence showing without permits or tags or current registration on the vessels, whatever the language
I
is.
didn't know they were an issue.
Okay.
But
Well,
I'm saying in the 15 days I'm given, if I can come up and show you that they are registered.
they would have to be registered within that 15 days or removed.
Well, I'm saying if I can show you proof that they are registered now.
Well, you're going to end up having to show that evidence to the city as far as abating the violations for them as junk vehicles.
But that would be showing it, correct?
If they have current registration on
If
them.
they have current tags and registrations for the boats and trailer, then it won't be in violation.
Okay.
But they're supposed to have a sticker on the side of the boat and a tag on the trailer.
Right.
Or current trailer.
Okay. Well, like I said, I'll issue the written order to that effect. You'll receive that at the property address. I think we sent it via certified mail. You'll receive that, and like I said, you'll have 30 days from the date of that order to appeal to circuit court should you so desire.
Well, hang on, let me get these, that's throwing me off here. So I've got 15 days to,
You've got 15 days to fix all this stuff.
from
To
the time I
get,
get the letter or?
yes,
the day?
from the date of the letter,
Okay.
or the date of the order, excuse me, to go ahead and get all the unsheltered storage off of there, get rid of the boats or get them tagged, and if you're going to get them tagged, provide evidence of that to the city.
Okay.
All right. We don't have anything further this morning, correct?
That's it.
Okay, with that, we'll
Would it
be,
be too much to ask for before that 15-day notice, you know, but I believe I've got it, I'd have asked you to come by and you'll take a look to see if I have.
Yeah, you can call, leave me a message and I'll come by
Okay.
and
Appreciate it.
verify it.
okay, with that having said, we're adjourned.
Right, thank you. Okay. What's the roll case number?
They are
You want these down?
1703, 152. Page 136. Yeah, they didn't have sewer hooked up and they had people living in the house back in 18. That was a month
What's
before
that?
the hurricane then.
Wasn't getting it.
And they were occupying it, and so I think
He hasn't
that
gotten
was
it the last two
Officer
times.
Brown brought both of those up.
And Finch, he just figures he can
And,
talk his
'cause
way
I
out.
remember that one. That was,
That's
and
not
then
right.
I think at that one too, I had a